Good day. Let's talk about lease today in sales. So what is a lease? A lease is a consensual, bilateral, onerous, and commutative contract by virtue of which one person binds himself to grant temporarily the use of a thing or to render some service to another. Consensual meaning there is the consent or the meeting of two minds. Bilateral meaning there are two parties involved. Onerous meaning there is a burdensome contract by which a person binds himself to. Commutative also meaning one gives and the other also pays. When we talk about lease, it is important to know the three kinds of leases from the viewpoint of the subject matter. One is the lease of things, two is the lease of service, and three is the lease of work. It is also important to know that since lease is a consensual contract and it is not imposed by law, only the lessor has the right to fix the rents. However, the increasing of the rent is not an absolute right on the part of the lessor. However, the exception also is that if there is stipulation in the contract of lease whereby increments or incremental increases shall be made year after year or upon renewal of the contract, then that shall be valid. So what are the characteristics or requirements or requisites for lease of things? One, it should be consensual. So there should be meeting of the minds and both parties consent to the contract. Second is it's a principal contract. And third, it's a nominate contract as part it has a name. It's a lease contract. Fourth is the purpose of this is to allow enjoyment or use of the thing, thereby the person to enjoy is the lessee, and the person allowing the enjoyment of another is called the lessor. Fifth is that the subject matter must be within the commerce of man. Sixth, the purpose to which a thing will be devoted should not be immoral. Number seven, that it is onerous. There must be rent or price certain. Eighth, the period is temporary, meaning it's not perpetual, hence the longest period is 99 years. Number nine, the period is either definite or indefinite, but if no term is fixed, we should apply Article 1682 for rural leases and Article 1687 for urban leases. And if the term is fixed but indefinite, the court will fix the term under the law of obligations and contracts. And number 10, the lessor need not be the owner. It is also important to know or note that a usufructuary may thus lease the premises in favor of a stranger, and such lease shall end at the time the usufruct itself ends. What again is a usufruct? It gives the right to enjoy the property of another, but it has the obligation corresponding to it, which is the preservation of the form and substance of such property, unless the title constituting it or the law otherwise provides. Now, this is also a temporary right of enjoyment, which includes both jus utendi, or the right to own or use the property, and then jus fruendi, or the rights to the fruits. But the owner still has retained the jus disponendi, or the power to alienate such property. Now let's talk about rent, because when you talk about lease, you cannot help but associate rent with it. Rent is the compensation either in money or provisions or chattels or labor received by the lessor from the lessee. So when a student boards and lodges in a dormitory, there is no contract of lease. The contract is not specifically designated in the Civil Code. As such, it is an inanimate contract. However, it is believed that the contract can be denominated as that of a contract of board and lodging. Now, there is a contract of lease when the use and enjoyment of a safety box or safety deposit box in a bank is given for a price certain. This is certainly not a contract of deposit, but a contract of lease. It is also good to note that a lease of personal property with an option to buy it at a nominal amount at the end of the lease can be considered a sale. Again, there are three kinds of leases from the viewpoint of the subject matter. First is the lease of things, second is the lease of service, and third is the lease of work. Let us distinguish lease from sales this time. Number one, as to what is being transferred. In lease, it's only the use or the enjoyment of the thing that is being transferred, while in sales, the ownership is being transferred. Number 2, as to the permanence of the transfer. In lease, the transfer is only temporary or at a certain period of time, whereas in sales, the transfer is permanent as the ownership too is being transferred. Number 3, as to whether the lessor should be the owner or not. In lease, the lessor need not be the owner, but in sales, the seller must be the owner at the time the property is delivered. Number 4, the price. The price of the object in lease is distinguished from the rent and is not usually mentioned because the rent is that's what's being paid for by the lessee. Now in sales, usually the selling price is mentioned because the actual total selling price will be paid by the buyer to the seller. Now let's differentiate lease of things versus lease of services. First, as to the object. In lease of things, the object of the contract is a thing, whereas in lease of services, the object is for some work or service to be done. Number 2, as to the delivery. The lessor in the lease of things has to deliver the thing leased, whereas in the lease of services, the lessor has to perform some work or service. And number 3, what are the remedies in case of breach? In lease of things, there can be an action for specific performance. As in lease of services, in case of breach, no action for specific performance can be remedied from. This time, let's differentiate lease of services versus contract for a piece of work because sometimes we interchange the two. Lease of services, or otherwise called as locatio operatum, has the important object that is the labor performed by the lessor because it's the lease of services, so services pertaining to the labor. However, in the contract for a piece of work called locatio operas, the important object is the work done. So this is the finished product for a contract of piece of work. And number 2, in the lease of services, the result generally is not important. Hence, the laborer is entitled to be paid even if there is destruction of the work through a fortuitous event. However, in the contract for a piece of work, the result is what is most important as a general rule. And generally, the price is not payable until the work is completed. And the said price cannot be lawfully demanded if the work is destroyed before it is finished and has been accepted. What about lease of services versus agency? There are two main differences between the two. First, in the lease of services, it is based on employment, meaning the lessor of the services does not represent his employer, nor does he execute juridical acts, whereas in agency is based on representation, since the agent represents the principal, and so the agent can enter into juridical acts on behalf of the principal and with his consent. In the lease of services, it is a principal contract, whereas agency is a preparatory contract. Now, what are the rules or what is the general rule for lease of consumable goods? The general rule for this is that consumable goods cannot be the subject matter of the contract of lease of things. And the reason? Because to use or enjoy them, they will have to be consumed. This cannot be done by a lease since ownership over them is not transferred to him by the contract of lease, right? So it has to be a contract of sale for consumable goods, except if, number 1, they are merely exhibited, and number 2, if they are an accessory to an industrial establishment. So what is the rule in the recording of lease of personal property? As a general rule, lease of real property is a personal right, meaning it is a right enforceable only against another person, except when the lease partakes of the nature of a real right. So a real right is one that is enforceable against the whole world, and thus it is a right over a certain object or a thing or a property, and therefore it can be registered in the registry of deeds. So if and when the lease of a real property is more than 1 year, and number 2, if the lease of real property is registered regardless of the duration, so that becomes a real right. So it is important to note that the lease of personal property cannot be registered, and to be binding against third persons, the parties must execute a public instrument. Therefore, it's notarized by an attorney. And then lease may be made orally, but if the lease of real property is for more than 1 year, it must be in writing under the statute of frauds. Otherwise, such lease will be void. It's also important to know who are these persons disqualified to be lessees, because by law, they are disqualified to buy from one another too. Number one, a husband and wife cannot lease to each other their separate personal properties, except for 1A, if separation of the property was agreed upon, so there's a prenuptial agreement, and B, if there has been a judicial separation of property. This could be following legal separation or annulment. The second persons to disqualified to be lessees because they are disqualified to buy are those persons mentioned in Article 1491. They are disqualified by virtue of their fiduciary relationships. What is Article 1491? The following persons cannot acquire by purchase even at a public or judicial auction, either in person or through the mediation of another. Number one, the guardian, the property of the person or persons who may be under his guardianship. Number two, the agents, the property whose administration or sale may have been entrusted to them unless the consent of the principal has been given. Number three, the executors and administrators to the property of the estate under administration. And number four, public officers and employees, the property of the state or of any of its subdivision of which has been entrusted to them. And this provision shall apply to judges and government experts who in any manner whatsoever may take part in the sale. When we talk about lease, we can't help but also mention or discuss sublease. What is it? It is actually a separate and distinct contract of lease wherein the original lessee becomes a sublessor to a sublessee. And it is allowed unless it is expressly prohibited, especially in your lease contract. The sublessee is subsidiarily liable for any rent due. The lessor has an action directa against the sublessee for unpaid rentals and improper use of the object. So what is a sublease agreement? A sublease agreement is one or a contract that enables a current lessee who is the tenant to further lease out the premises to another lessee or a subtenant or sublessee while remaining the main occupant according to the master lease agreement. Well, the original tenant here is still liable for the obligations in the original lease agreement, especially in the paying of the monthly rentals. So what is the difference between an assignment lease and a sublease? So there are four distinguishing factors or differences between sublease and the assignment of lease. First is with regard to the number of leases. In sublease, there are 2 leases and 2 distinct juridical relationships, although immediately connected and related to each other because there's a connection between the lessor and the lessee, and then there's a connection between the lessee and the sublessee. On the other hand, the assignment of lease has only one juridical relationship, and that is between the lessor and the assignee who is now converted into a lessee. Second is the personality of the lessee. In sublease, the personality of the lessee does not disappear. But on the other hand, in the assignment of lease, the personality of the original lessee disappears. Number 3, as to the transmission of rights and obligations. In sublease, the lessee does not transmit absolutely his rights and obligations to the sublessee. In fact, he is still obligated to pay in the monthly rentals, just in case the sublessee fails to do so. In assignment of lease, on the other hand, the lessee transmits absolutely his rights to the assignee. And the fourth characteristic is with regard to the right of action. In sublease, the sublessee generally does not have any direct action against the lessor or the original lessor, whereas in the assignment of lease, the assignee has a direct action against the lessor because there is already a juridical relationship between the two of them. So what are the rights of the lessor if the sublease is prohibited but entered into by the lessee? First, there is the rescission of the contract plus damages. Number 2, there is damages only that can be remedied by the lessor if the contract will be allowed to remain or stay in force. And number 3 is for the lessor to file an ejectment case against the lessee. What are the instances when a sublessee is liable to the lessor? Because we discussed earlier that the sublessee is not directly liable to the original lessor. First, in all acts which refer to the use and preservation of the thing, leased in the manner stipulated between the lessor and the lessee. So for instances, there are damages and repairs that need to be done on the thing or the property that was being subleased. The sublessee is then now liable to the lessor for that. And number 2, when the sublessee becomes subsidiarily liable to the lessor for any rent due from the lessee. So both the lessee and the sublessee are subsidiarily liable if in case any one of them fails to pay the rent due to the lessor. It is also important to note that the sublessee shall not be responsible beyond the amount of rent due from him, as stipulated in the sublease contract or agreement. Now, the remedy for the lessor, or what that the lessor may bring against the sublessee for misusing the sublease property, could be action directa. Action directa is the right of a person to go directly against another who is not privy to the contract, because when you go back to the original lease contract or lease agreement, it is between the lessor and the lessee, and not between the lessor and the sublessee. But because of the liabilities that the sublessee shall be responsible for to the original lessor, he can have, or the lessor can avail of the action directa. That's it for me. Let's proceed to the other remaining topics on lease. Have a great day.
Good evening once again. The next part of our report will talk about rights implications of the lessor and the lessee. What are the obligations of the lessor? Article 1654 of the Civil Code provides for the obligation of the lessor. First, the lessor is obliged to deliver the thing which is the object of the contract. The object must be in the condition fit for the use intended. Second, the lessor is obliged to make necessary repairs in order to keep the thing suitable for the use to which it has been devoted, unless there is stipulation to the contrary. Third, the lessor is obliged to maintain the lessee in the peaceful and adequate enjoyment of the lease, for the entire duration of the contract. This obligation of the lessor seeks to protect the lessee, not only from the acts of third persons but also from the acts of the lessor. In addition to those provided in Article 1654, the lessor is obliged not to alter the form of the thing leased. Lastly, the lessor has the obligation to protect the lessee covers acts of third persons and of the lessor. The following are the rules on alteration of the form of the lease. Article 1661 states that the lessor can alter the lease, provided there is no impairment of the use to which the thing is devoted under the terms of the lease. To constitute alteration, the modification must be in such a manner that it would destroy the substance of the thing leased, unserviceable for the use intended. Moreover, the lessee can alter, as long as the value of the property is not substantially impaired. How about when the lease contract contains right of first refusal? The rule is that the lessor is under a legal duty to the lessee, not to sell to anybody at any price, until after he has made an offer to sell to the latter at a certain price, and the lessee has failed to accept it. The sale in violation of such right is nevertheless valid. However, it may be rescinded or may be the subject of an action for specific performance. Rules in case of useful improvements and ornamental expenses. So what are the rights of the lessee in case of useful improvements? First, the lessee has the right to remove the improvements, should the lessor refuse to reimburse, although the principal may suffer damage. Second, the lessee has the right to be reimbursed by 1/2 of the value of said improvements, at the time of termination of the lease, should the lessor choose to appropriate it. The lessor is to pay only 1/2 of value of the improvements at the time the lease terminates, because the lessee has enjoyed the same. On the other hand, the lessor will enjoy them indefinitely thereafter. To be entitled to either of the two remedies in the preceding slide, the following must concur. 1. The lessee must be considered a builder in good faith. Improvements can be considered made in good faith if they are not in violation of the lease contract. 2. Improvements must be suitable to the use for which the lease is intended, and 3. The form and substance of the property should not be altered. How about an ornamental expenses? What right does the lessee have? The lessee has no right of reimbursement, but he may remove the improvements, provided that no damage is caused to the principal thing, and that the lessor does not choose to retain them by paying their value at the time of the lease. Now, we go on the rules in case of urgent repairs. The Civil Code provides that the lessor has the obligation to make necessary repairs, and that the lessee is obliged to notify the lessor of the urgency of the repair. The Civil Code further provides that the lessee is obliged to tolerate the work, although it may be very annoying to him, and although during the same time he may be deprived of the part of the premises, if repairs last for less than 40 days. Who has the burden of proof? It is the lessor who has the burden to prove the urgency of the repair. What is the right of the lessee if the repair lasted for more than 40 days? The lessee can ask for reduction of the rent, in proportion to the time, including the first 40 days, and the part of the property of which he is deprived. However, if the repair lasted for less than 40 days, the lessee cannot ask for reduction of the price, in the absence of the provision in the contract giving him such right or for rescission. It must be noted that in either case, rescission may be availed of, if the main purpose of the lease is to provide a dwelling place for the lessee, and the property becomes uninhabitable. If the repairs however are not urgent, the lessor is liable for any damages suffered by the lessee. What are the remedies if the lessor fails to make urgent repairs? The lessee has the following alternative remedies. First, he may order repairs at the lessor's cost, to avoid imminent danger. Second, he may ask for indemnification for damages. Third, he may suspend the payment of the rent, or lastly, he may ask for rescission, in case of substantial damage to him. In the case of Brandzone vs. Sublease, it was held that if the lessor refuses to make urgent repairs despite notice, the remedy of the lessee is to make urgent repairs themselves and to charge the cost of the lessor, and not to suspend payment of rentals. So let's proceed to the obligation of the lessee. Article 1657 of the Civil Code enumerates the obligations of the lessee. First, the lessee is obliged to pay the price of the lease according to the terms stipulated. Note that only the lessor has the right to fix the rents. The lessor has the right to increase the rent in case of renewal. The lessee has the option to accept the new rate or vacate the premises, otherwise, he will be considered a possessor in bad faith of the property. Second, lessee is obliged to use the thing leased as a diligent father of a family would, devoting it to the use stipulated, and in the absence thereof, to that inferred from the nature of the thing leased according to the custom of the place. The lessee shall then be held liable for any deterioration caused by members of his household, guests and visitors. Third, to pay expenses for the deed of lease. However, this may be assumed by the lessor if agreed upon by the parties. In addition to those provided in Article 1657, the lessee is obliged to make urgent repairs even if annoying to him, unless the becomes uninhabitable. He is also obliged to notify the lessor of usurpation or untoward acts, which any third person may have committed, or may be openly preparing to carry out upon the leased thing. It is necessary to notify the lessor, so that the latter may bring proper action against the usurper. Further, it is unjust to compel the lessor to stand idly and trust the defense of his property to a mere lessee. The lessor is likewise obliged to notify the lessor of the need for repairs in the thing leased. However, notification is not essential if the lessor actually knows the need for the repairs. It should be noted that if the lessee failed to notify the lessor, he would be liable for damages, which the lessor would suffer, and which could have been avoided by the lessee's diligence. Lastly, the lessee has the obligation to return the property leased upon termination of the lease, in the same condition as he received it, save what has been lost or impaired by a. lapse of time, b. ordinary wear and tear, or c. inevitable cause or fortuitous event. That's all for the obligations of the lessor and the lessee. Thank you for listening.
And now let's proceed to the difference between the four civil actions provided for the lessor. There are three kinds of action for the recovery of possession of real property. First, action interdictal or an ejectment proceeding, which may either that for forcible entry or unlawful detainer, which is a summary action for recovery of physical possession where the dispossession has not lasted for more than 1 year and should be brought in the proper inferior court. Second, action publicana, or the plenary action for the recovery of real right of possession, which should be brought in the proper regional trial court when the disposition has lasted for more than 1 year. And third, action reivindicatoria, or action de reivindicación, which an action for the recovery of ownership, which must be brought in the proper regional trial court. Now, let's discuss the so-called forcible entry. So what is forcible entry? Under the rules of court, Rule 70, Section 1, it is the possession of a land by the defendant by force, intimidation, threats, strategy, or stealth. For a forcible entry suit to prosper, the plaintiffs must allege and prove that they have prior physical possession of the property, that they were deprived of possession either by force, intimidation, threat, strategy, or stealth, and that the action was filed within 1 year from the time the owners or legal possessors learned of the deprivation of the physical possession of the property. There is only one issue in ejectment proceedings: who is entitled to physical or material possession of the premises? That is, the possession de facto and not possession de jure. As to nature, it is summary action for the recovery of the physical possession where the dispossession has not lasted for more than 1 year. As to prior possession, the plaintiff must prove that he was in prior possession of the premises until he was deprived thereof by the defendant. As to prior nature of possession, it is the possession of the land which is unlawful from the very beginning. As to necessity of demand, it is not required before the filing of the action. As to the time when action was brought before the court, within 1 year from the time the cause of action arises. In forcible entry, the cause of action arises from the date of actual entry of the land. In case of strategy or stealth, the cause of action arises from the date of discovery of such strategy or stealth. As to which court has jurisdiction, all cases of forcible entry and unlawful detainer, irrespective of the amount of damages or unpaid rentals sought to be recovered, should be brought to the MTC. However, if not brought within 1 year from the time the cause of action accrues, RTC has jurisdiction. And lastly, let us remember that the underlying philosophy behind ejectment suits is to prevent breach of the peace and criminal disorder and to compel the party out of possession to respect and resort to the law alone to obtain what he claims is his.
And now let us discuss what is ejectment. They are summary proceedings designed to provide for expeditious means protecting actual possession or the right to possession of the subject property. The actions for forcible entry and unlawful detainer belong to the class of actions known by the generic name action interdictal, where the issue is the right of physical or material possession of the subject real property independent of any claim of ownership by the parties involved. Unlawful detainer. It is an action for recovery of possession from defendant whose possession of the property was inceptively lawful by virtue of a contract, express or implied, with the plaintiff but became illegal when he continued his possession despite the termination of his right thereunder. So what are the elements of unlawful detainer? First, possession of the property by the defendant was by contract with or by tolerance. Second, eventually such possession became illegal upon notice of the termination of right of possession. Third, the defendant remained in possession of the property and deprived plaintiff of the enjoyment thereof. And lastly, within 1 year from the last demand on defendant to vacate the property, the plaintiff instituted a complaint for ejectment. So when is possession considered unlawful? It is only when the defendant fails to comply with the demand that his possession becomes unlawful. A person who occupies the land of another at the latter's tolerance or permission without any contract between them is necessarily bound by an implied promise that he will vacate upon demand, failing which an action for unlawful detainer may be instituted against him. When there is implied renewal of lease, there is no unlawful detainer. An implied renewal of lease will set in if it is shown that the term of the original contract of lease has expired, the lessor has not given the lessee a notice to vacate, and lastly, the lessee continued enjoying the thing lease for 15 days with acquiescence of the lessor. So who may institute the action and when? In unlawful detainer, the lessor, vendor, vendee, or other person against whom any land or building is unlawfully withheld, or his legal representatives or assigns. And the period of filing is within 1 year after the unlawful deprivation or withholding of possession, discounting from the date of the last demand. The exclusive original jurisdiction over forcible entry and unlawful detainer suits is with the MTC. As a general rule, all actions of forcible entry and unlawful detainer shall be governed by the summary procedure of Rule 70, irrespective of the amount of damages or unpaid rentals sought to be recovered, except in cases covered by agricultural tenancy laws or when the law otherwise expressly provides. And now let us compare forcible entry and unlawful detainer. In forcible entry, possession of land by the defendant is unlawful from the beginning as he acquires possession by force, intimidation, strategy, threat, or stealth. In unlawful detainer, possession is initially lawful, but it becomes illegal by reason of the termination of his right to possession of the property under his contract, expressed or implied with the plaintiff. In forcible entry, no previous demand for the defendant to vacate the premises is necessary. In unlawful detainer, demand is jurisdictional. In forcible entry, plaintiff must prove that he was in prior physical possession of the premises until he was deprived thereof by the defendant. In unlawful detainer, plaintiff need not have been in prior physical possession. In forcible entry, the 1 year period is generally counted from the date of actual entry on land. In unlawful detainer, period is counted from the date of last demand. So let's have a case, Cananay vs. Sarmiento, GR number L1246-1947. So for the facts of the case, on or about January 15, 1920, Cananay and her daughter entered into a verbal contract with Feliciano Sarmiento whereby the latter leased to the former the land under an agreed rental of 3 pesos a month. They have so far paid to the plaintiff the amount of 130 corresponding to the rentals for the months of January 15, 1920 to August 25, 1923. Thereafter, the defendant failed to pay the rent since after August 25, 1923. Plaintiff has several times verbally demanded of the defendants to pay the unpaid rentals and to vacate the premises, the last demand having been made on them personally and in writing on August 3, 1946. But they have failed and refused and still continue to fail and to pay the rentals, now amounting to 828, and to vacate the premises. As an affirmative defense, defendant alleged that she acquired the property in question by prescription for having possessed it over a period of 20 years. So for the issue whether the complaint was filed within the 1 year period prescribed, the court ruled that the 1 year period provided therein must be reckoned from the date of the unlawful deprivation or withholding of possession. It is alleged that plaintiff has several times verbally demanded the defendants to pay the unpaid rents and to vacate the premises, the last demand having been made on them personally in writing on August 3, 1946. Under the said paragraph, it is evident that the unlawful deprivation or withholding of possession stated on August 3, 1946, and formal demands for vacating the premises was made. The fact that it is alleged in the complaint that defendant failed to pay the rent since after August 25, 1923 does not make unlawful defendants withholding of possession of the property. Mere failure to pay rents does not ipso facto make unlawful tenants possession of the premises. It is the owner's demands for tenant to vacate the premises when the tenant has failed to pay the rents on time, and tenant's refusal or failure to vacate which makes unlawful withholding of possession.
Good evening. This is Pedro Francisco, and I am here to talk about actions to recover. Now, recovery of personal property, or it can also be recovery of real property. Now, when we say recovery of real property, there are different ways or modes in which we may be able to do so. By filing a proper action in court, it can be through forcible entry, unlawful detainer, action publiciana, and action reivindicatoria. Now, on my end, I was assigned, no, in both action publiciana and action reivindicatoria. Action publiciana. So what is action publiciana? The action publiciana is intended for the recovery of the better right to possess and is a plenary action in an ordinary civil proceeding before the regional trial court and must be brought within a period of 10 years. Otherwise, the real right of possession is lost. 1 year, the action to recover falls within the jurisdiction of the RTC. The Commonwealth Act 53538, which provides for the automatic suspension of an action for ejectment against tenants occupying lands which the government desires to acquire through purchase or expropriation proceedings. It applies only to forcible entry and unlawful detainer cases, and not to action publiciana. Now, in the case of Reyes versus Honorable Santa Maria, the facts of the case states that petitioner sued for to recover property, which is a land, a lot, which respondent refused to deliver on the ground that the respondent, was the owner thereof, having purchased the same from the third person. Is this a case of unlawful detainer? The Supreme Court held that no, it is a case of action publiciana, for the claim is for possession de jure, and not de facto. Thus, the CFI, now RTC, had jurisdiction. It should not have dismissed the case on the theory that the matter involved an unlawful detainer, which should have been filed with the municipal trial court. Now, what is the difference between possession de jure and possession de facto? When I say possession de facto, it is possession that is without any legal basis, while possession de jure, it is backed up with the legal basis. No? Okay. Now, there are two kinds of plenary actions to recover possession in action publiciana. Now, one is that where the entry was not obtained through fists. Fists refers to fraud, intimidation, stealth, threat, or strategy. This can be brought as soon as the dispossession takes place without waiting for the lapse of 1 year. Failure to state that deprivation was caused by fists would make the action not one of forcible entry but action publiciana. Thus, where the complaint not only shows prior possession by the defendant, but also fails to allege that the plaintiff was deprived by fists, no case of forcible entry is made out, and the justice of the peace court has no jurisdiction over the case. Justice of the peace refers to the municipal trial court, or the justice of the peace court. Second, that where 1 year period for bringing forcible entry or unlawful detainer has already expired. Here, the action may still be brought after the 1 year period as action publiciana. In the regional trial court, no, in the regional trial court. Hence, if brought before the RTC before the expiration of the 1 year period, the action would still be either forcible entry or unlawful detainer, and therefore the RTC would not have jurisdiction. If forcible entry or unlawful detainer has already been brought or decided upon by the justice of the peace or municipal trial court, may the subject be again threshed out in an action may an action may the subject be again threshed out in an action publicana brought after the expiration of the 1 year period. The Supreme Court on this point has answered in the negative on the ground that this would present a real case of res judicata, or shortly, this means that the case has already rested, no, and it is final. Note that an action publicana, which naturally is res judicata only insofar as one of the parties is held to have a better right of possession, does not bar a subsequent action between the same parties where one seeks to compel the other to execute a formal deed of sale over the same property to enable him to obtain a transfer certificate of title in his name and to quiet title over the same. So that is action publicana. Now, in the case of Patricio S. Cunanan versus Court of Appeals, Cunanan in an action publicana sued in the CFI, now the RTC, a certain Basaran, alleging that the latter had usurped the former's property for over a year before Cunanan instituted the action. On the basis of this allegation in the complaint, does the RTC have jurisdiction over the case? The court, the Supreme Court held that yes, for more than 1 year had elapsed since the usurpation. If only 1 year or less had elapsed, the action should have been instituted in the municipal court as a forcible entry or as an unlawful detainer case, depending on the facts alleged. Now, let us talk about action reivindicatoria. The action reivindicatoria or reivindicatory action is defined as an action to recover ownership over real property. The action must be brought in the regional trial court where the real estate is situated. The fact that the venue of the improvements on the land is less than the jurisdictional amount does not deprive the RTC of its authority to take cognizance of an action reivindicatoria. Of course, if there are pending title proceedings of the public land involved, pending in the Bureau of Lands, and the attention of the RTC is called on this point, the said court must dismiss the suit, not for lack of jurisdiction, but for lack of cause of action. If the attention of the RTC is not called on this matter, it can still proceed to hear the case. It must be brought within 10 years or 30 years, as the case may be, depending on whether the other party seeks to obtain ownership by ordinary or extraordinary prescription. Note, insofar as real property is concerned, ordinary prescription, which requires, aside from other requirements for prescription, good faith and just title, runs for 10 years. Extraordinary prescription, which does not require good faith or just title, runs for 30 years. Note again, when brothers through fraudulent representations have been able to succeed in obtaining title in their names of a parcel of land, thereby depriving their sister of her rightful share in the inheritance of a constructive trust is created in favor of said sister. She has therefore the right to vindicate the property regardless of the time that has elapsed. It should be observed, however, that this doctrine of imprescriptibility of an implied trust would seem to be directly at variance with the rule stated in the case of J.M. Tuason and Company versus Magdangal, no? And Cornelio Alzona et al. Versus Gregorio Capunan et al. That an action for reconveyance based on an implied or trust rather prescribes in 10 years. Another note, one of the actions which does not lapse by death, again, one of the actions which does not lapse by death is that for the recovery of title or possession of real estate. Now, this is exemplified in the case of Sison and Araga versus Balgos, 34 Philippines, 885. Now, in the reinvocatory action, reinvican, re, in reivindicatory action, the issue involved is ownership. And for this purpose, evidence of title or mode may be introduced. On this point of ownership, the action differs from action publicana, where the issue is the better right of possession, which is possession de jure, and from forcible entry or unlawful detainer, where the issue is material possession or possession de facto. All three actions, however, though involving real property, are actions in personam, and therefore binding only upon the parties and previous thereto. Just as a defendant in a forcible entry or unlawful detainer case in a justice of the peace court or a municipal trial court may not quash it and convert the suit to one of revindication cognizable only by the RTC, by claiming in this motion or answer that the case involves ownership or title. So also may a defendant in a case involving title to property not convert it into a suit for ejectment or illegal detainer by merely asking for possession of the property by means of a counterclaim. Now, in the case of Armamento versus Guerrero, the Supreme Court clarified and stated, it is true that the basic rule is that after the lapse of 1 year, a decree of registration is no longer open to Article 428 Civil Code of the Philippines, 126 review or attack, although its issuance is attended with fraud. This does not mean, however, that the aggrieved party is without remedy at law. If the property had not yet passed to an innocent purchaser for value, an action for reconveyance is still available. If the property already passed to an innocent purchaser for value, the action is one for damages. Now, this is exemplified in the case of the Director of Lands versus Register of Deeds of Rizal, 92 Philippines 826, for damages, not one, to set aside the decree. It is permissible to file both an action for ownership, revindicatoria, and for detainer over the same lot and between the same properties because the issues involved are different. Moreover, execution on the detainer can issue as soon as the judgment thereon becomes final. This is true even if the reivindicatory action is still pending. Now, in the case of Javier et al. Versus Osmeña et al., A brought an action to recover the ownership of a piece of land against B. A was declared the unlawful owner. A then proceeded to the land where he found C and D possessing the same. With the help of the sheriff, A succeeded in ejecting C and D from the land. C and D now complained that in the action filed by A and B, C and D were not made parties in the proceedings, and that therefore the ruling made by the court should not be enforced against them. Are C and D correct? Yes, C and D are correct. Revindicatory action is not an action in rem, but an action in personam. It should therefore bind merely those who had been made parties to the action. Judgments rendered in actions in personam are enforceable only between the parties and their successors in interest, but not against the strangers thereto. Now, now you may also see section 306, paragraph 2 of Act 190, now Rule 39, section 47 of the Rules of Court. Summarily stating, action publicana as compared to action revindicatoria is the recovery of a better right to possess, and is a plenary action in an ordinary civil proceeding before the RTC. Must be brought within a period of 10 years, otherwise the real right to possess is lost. Issue is possession de jure, not de facto. In action revindicatoria, action to recover ownership over real property. It must be brought in the RTC. It must be brought within 10 or 30 years, as the case may be. Issue involved is ownership, and for this purpose, evidence of title or mode may be introduced. It is permissible to file both an action for ownership and for detainer over the same land between the same parties, because the issues involved are different. That ends my presentation today. Thank you for listening. Good night.